Good evening, this is John Milburn for Laws 13010, Evidence and Proof. We are really into the home straight. We're in week 10 and the second assessment is due tonight. So if you're watching us as a recorded session, I hope that you've already uploaded your work. And for those of you that have already uploaded your work, thank you very much. I hope you enjoyed the exercise. It's not often that you have the part of your assessment an opportunity to watch a classic movie, so something a bit different. Now, we need to get into the study for the examination in earnest, and prior to coming on screen, Michael indicated he's already started doing some past exams, and that's an excellent strategy. So if you're looking for some clear guidance on how to complete your examination preparation, do some past exams. And that is essentially the extent of feedback that I'll provide you. I'll provide you with some more feedback on that, but it's really the best way to go. And the examination this year will be of a similar style to the examination last year. So if you complete the past year's examinations, have a look at my level 3 video on preparing for an exam. You'll get an idea of what it is that I generally want you to do. Now, if we have any questions as we proceed tonight, please use the chat facility or feel free to unmute the microphone and ask a question live. Statements as circumstantial evidence can be used in two ways. One, to provide evidence as to the state of mind of someone. And whenever I hear that phrase, state of mind, I always think of Subramaniam's case. But it's only one of a number of cases that provide the evidential, circumstantial value of statements. And statements that are made can have circumstantial value because of the effect it's assumed to have on the recipient, as was the case in Subramaniam, or what may be inferred regarding the mental state of the maker of the statement. So bear in mind there are two distinct ways to look at this in terms of circumstantial value of statements that were made. So let's have a look at firstly at the effect that the making of the statement is assumed to have on the recipient. Again, think Subramaniam. And more particularly now, let's think about the scenario where we're considering the value of statements as circumstantial evidence in the context of whether it has probative value regarding the state of mind of an accused. That is, as the recipient of the statement. So just so that I'm clear on this as best I can be, we're talking about statements that were made by the accused or someone who is not the accused. That's one subcategory. And the second is, we're talking about the effect of the statement on the person who made the statement or on the state of mind of the person who received the statement. So you can see that there are four different scenarios that we can potentially talk about when we're talking about this general topic of statements as circumstantial evidence going to state of mind or intention. So generally speaking, it is open for a jury to consider what is essentially a hearsay statement to determine the state of mind of a recipient. Let's give an example. A discharges a shot into B's face. At the trial, A pleads accident. Witness C handed the shotgun to A and C said, "Be careful with it, it's loaded." So you have the scenario in mind. This is evidence because it goes to the assumed state of mind of the recipient, which is A. That is the recipient of not only the statement, but also the gun. So it's evidence to the effect that A must have known the gun was loaded because the information was provided by C to that effect, albeit that it's a hearsay. So you might be saying, well, why is C's statement hearsay at all? But C gives evidence and says to the court, this is what I said. Why in this context is what C said as hearsay? And it gets very tricky, I know that. So the answer is, if the prosecution intended to prove by the statement that the gun was loaded, then it is hearsay. There might be an exception if C was the one who actually loaded it. But the evidence by C at that point is altogether different to direct evidence of C in the witness box that the gun was loaded in a trial. So the statement that was made at the scene, relayed later, even by C, is hearsay. And that's as opposed to direct statement of evidence at the time of giving the evidence in the witness box. I know that gets a bit tricky. So again, we have a different category, subcategory. We're talking about statements that were made at the time of a relevant offence, or event rather, as opposed to the evidence that was provided in the witness box before the jury, so to speak, which is direct oral evidence. And the evidence given in court under oath by the witness is really that of their account of what they perceived with one of their senses. So evidence about what the witness himself said at a time earlier than the trial is in fact first-hand hearsay. Evidence about what the witness said that someone else said before the trial is second-hand hearsay. All right? No corroboration. And if you're totally confused at this stage, I understand. But the difference is what was said in the witness box, or what is said, given evidence in the witness box, is the actual evidence. And merely saying something about what you did or what you said at an earlier time is really you giving hearsay evidence about yourself. Because you think about the direct evidence, which is not hearsay, is that which is tested in the witness box. Let's go on with another example. And we're talking about the value of statements made going to the state of mind of a victim as the recipient of the statement. Now, the key case here is Bull against the Queen, 2001, CLR 443. So it's a case decided in 2000, and the reference is, or the citation is 201, CLR 443. So in this case, the accused was allowed to call evidence of a telephone conversation between the complainant and one of the accused that suggested that she accepted an invitation to his house. The evidence in that telephone call was that she was told that other men were present, she could participate in to act out a sexual fantasy, and the evidence was admitted as part of the defence case relating to consent. The evidence was admitted to show what the complainant's state of mind, and therefore an intention, must have been when she agreed to go to the house. So on that basis, this hearsay evidence was allowed. But there are similar variations, and you can read about this in your textbook, in relation to the assumed state of mind or intention of the maker of the statement. So a case there is Walton against the Queen. So the facts of Walton against the Queen, which was a 1989 High Court decision, 166 CLR 283, was the victim's body was found in deserted country north of Elizabeth in South Australia. Walton was convicted of the murder of the victim, and the victim was his former de facto spouse. And Walton's new wife gave evidence at the trial. That doesn't sound good for Walton, does it? If the new wife gives evidence in relation to the alleged murder of the former de facto. Anyway, Walton's new wife testified against Walton in return for not being prosecuted as an accessory herself. And he said that Walton discussed his plans with her. Walton stated his intention to set up a meeting with the victim in Elizabeth. So that's one statement that was made and admitted into evidence that goes to a state of mind or intention. It's clearly hearsay, but it was admitted into evidence. And then we get a little further. Witness R testified that she had been with the victim when the victim received a call from someone, and the Crown maintained that that someone was Walton. And the victim called her son to the phone and said, "Daddy's on the phone." And at the end of the call, the victim told R, this further witness, that the caller was Walton. So that's a second statement. So again, hearsay statement, the victim is dead. So the question for the court is, would they allow the new wife and R to give evidence of these statements? Because they were simply recipients of statements, weren't they? Or they, if you like, they overheard. But the question was whether these circumstantial statements, which are really hearsay, could be admitted to go to provide evidence as to the assumed state of mind of the maker of the statements. That is, Walton in statement 1 and the victim in statement 2. Now, the High Court admitted both statements and said they're both admissible. The victim's declared intention to meet with Walton, which was statement 1, described her state of mind when she made it. The presumption of continuance was then employed to infer circumstantially that she kept the appointment with Walton. Now, the second statement under consideration, the telephone call, statement 2, was admitted as original evidence of the fact that both the victim and her son believed it was Walton. So it went to the belief system in that regard. So Walton against the Crown, another important case. Now, probably the most important of all of these cases, which deals with statement of knowledge of a previous event, is quite a famous case. Those of you that were fans of, or maybe still fans of the series Rake, might be aware of one episode in which case someone was hired to kill someone else and they botched it up. Now, that was loosely based on the case of Polit against the Queen. So P-O-L-L-I-T-T against the Queen, 1992, 174 CLR 558. Polit was charged with murdering S. Now, what did the Crown allege this? They alleged that P, Polit, intended to murder W. That's what they said. Polit intended to murder W, and it's alleged that A hired Polit to murder W. A died before the trial, so the person who was said to be behind all of this was not available to give evidence. But A made various statements to Mr. and Mrs. B that implied that he knew all about the murder and knew all about the fact that the wrong person was killed. See, what had happened is that Mr. and Mrs. B were in A's company when they received a call from, when he received a call from somebody. So you got the picture? Mr. and Mrs. B are with A. A said to be the guy behind all this. He's now dead. He can't give evidence. But the evidence of Mr. and Mrs. B is that A got a call from somebody. And during the call, A became angry and told the person on the other end of the line, "You'll get the rest of the money when you do the job properly." Hint, hint. A put the phone down, told Mr. and Mrs. B that that was Polit on the phone. So the question for the court was, would they allow Mr. and Mrs. B to give evidence of the statement made by A, now deceased? In other words, whether the telephone call is an exception that would be allowed against what is clearly otherwise hearsay. And the High Court ruled that the evidence of Mr. and Mrs. B was admissible because the evidence showed that the person on the other end of the line was Polit. Therefore, by circumstantial inference, Polit was the killer. Of itself, not enough, clearly, to secure a conviction. But if we think in terms of the ropes in a strand version of circumstantial evidence, it's just another important strand, or link if you like, but more strand in obtaining a conviction against Polit. Any questions about those three key cases that we've discussed so far? Bull, Walton, Polit. You'll need to know those. Okay. Also be aware of the common law exception to the hearsay rule, which are circumstances that give veracity to various statements. So you got to understand that when it comes to hearsay, there are a number of reasons why, generally speaking, it's not admissible. One of them is that it's inherently unreliable, and courts need to work on reliable information, reliable evidence. Hearsay is pretty unreliable, generally speaking. But there are some exceptions where the common law says, look, this is hearsay, but we think it's pretty reliable given the circumstances, and therefore, given those circumstances, it becomes, it has value, it has some degree of veracity. There's something rings true about the circumstances. So what are these common law exceptions? Well, number one is res gestae. Number two are declarations made by persons now deceased. Number three, declarations about health, fitness and mental state. Number four, statements made in previous proceedings. And number five, informal admissions. So they're the common law, 5 common law exceptions that provide generally for the admission of what would otherwise be inadmissible hearsay evidence. So does anyone know what res gestae means? What's that all about? So we're talking about an exception to the hearsay rule at common law, going to the heart of the case. Yes. Slightly different angle I'm looking for, but thank you, Nicole. That was good. Any other takers? What do we mean by res gestae?
Was a statement made
contemporaneously
with an event?
Exactly. That's it. And Nicole's right. It would go to the very heart of the case. But the key point, thank you, Marcus, is that the res gestae exception to hearsay rule applies to the admission of such utterances, as if I can use that term, that people make at the very moment of a critical event occurring. And the common law says, well, at that time, before they've had a chance to think about it, to distort the information, it just comes out, and therefore it's likely to be truthful and you can rely upon it. But there are, of course, some rules that relate to the admission of hearsay evidence based on the res gestae exception. The first is it has to be, as Marcus says, contemporaneous. It's got to be at the time when the event is described. And also the second thing is the event itself must dominate the mind of the utterer to the exclusion of any opportunity for quiet reflection or invention of some falsehood. In other words, it's overwhelming and it's immediate. So there are the general rules, but the exception, but the requirement for it to be contemporaneous at the moment can be relaxed. And whether it's at that time, it can be something that occurs prospectively or retrospectively, which provoked the statement that was made. So an important case that deals with an utterance made before an event occurred is Ratan against the Queen. Now, this is an English decision. Ratan against the Queen. It's pretty important. 1972, appeal cases 378. Ratan was charged with shooting murder of his wife, and his defence was accident. Now, the Privy Council said the Crown should adduce evidence of a telephone call, or could adduce evidence of a telephone call 5 minutes before the shooting. So this is part of, if you like, the res gestae immediately before the event. And it was by a woman in a hysterical state who called the recipient and said, "Get me the police, please," and then hung up. So at that stage, clearly not murdered. And remember that Ratan was charged with the shooting murder of his wife. But this call made by a woman from the home 5 minutes before the event of which led to murder, the question was, should it be admitted? Now, the Privy Council said, well, firstly, it's not hearsay, but if it is, then we're prepared to allow it to fall within the res gestae exception to allow it to be admissible. So that's an utterance before the event. An example of an utterance after the event is the Crown against Andrews, which is 1987, appeal cases 281. So Andrews was charged with the stabbing and robbing of M. Now, a few moments after the attack, bleeding heavily from a serious stomach wound, M staggered downstairs to a unit and identified A as one of his assailants, and this person died before trial. But you can see after the event, this person, M, has made a statement. And the House of Lords in this case adopted a broader formulation of the res gestae rule in Ratan and said there are a few things that we will allow for this to be triggered. Again, if it dominated the mind of the maker, well, if you've got a stomach wound and someone's just stabbed you, that's pretty easy to establish that that's dominating your thinking. That there was no real opportunity for reasonable reflection. Someone's just been stabbed, they've staggered down some steps. They're not likely, says the law, to have had an opportunity to say, great, I'll use this as an opportunity to frame A. The next is reasonably or realistically, whether a concoction or distortion could be safely disregarded, whether there was no special feature that would suggest a motive for fabrication, and there was no special reason why the maker was affected by substances, for example, that could create an error. So that's what the House of Lords in Andrews expanded upon these principles that were sort of referred to and considered in Ratan. So Andrews is an important case and Ratan is also an important case. Now, when it comes to the Commonwealth jurisdiction, have a look at Section 9 of the Evidence Act, and you'll see Section 9 of the Evidence Act Commonwealth provides for an effect of an act of the Act on other laws, and you'll see essentially that it applies the common law and equity, such as the res gestae exception, in terms of the application of the Act. So when we're talking about the common law, always bear in mind the possibility that statute has either embraced it or changed it. I won't go into more detail about that. If you want to read some more, there was an excellent decision of Brown against Berger, 2017 Q2 QDR 639, which deals with the res gestae exception. It went to appeal, but the primary judge decision is very good for setting out a lot of these things. I'll also get you to read through your text in terms of declarations by a person now deceased, and bear in mind that the position in that regard is now covered by both the Evidence Act Commonwealth, or Uniform Evidence Act as we say, and the State Evidence Act. Also think about declarations about health, fitness and mental state, statements made in previous proceedings, and informal admissions. Just on that point of statements made in previous proceedings, you can understand from a defence perspective how important that is potentially. So what we're saying is that any statement that was not made under oath in the proceedings is essentially hearsay, even if you're the one that's made the statement previously. But there's an exception to that if the statement by the witness was made in previous proceedings as a sworn statement of evidence under oath. That might, in criminal law trials, that might occur, for example, where there was a mistrial for whatever reason. All right, all good? Now, can anyone tell me, in general terms, the difference between a confession and an admission? And I'll give you a hint. I'm thinking of this. Yes, sorry. Yes, Marcus?
Sorry, one's civil, one's criminal.
Yeah, that's it. And so that was the general hint. So good on you. Now, it's not strictly applied in that regard, but as a general rule, that's a good way of thinking about it. So thank you. To be admissible, confession or admission must constitute first-hand hearsay. Again, have a look at Section 81, or have a look at the Commonwealth Act and have a look at Section 81 in terms of hearsay and opinion rules, exception for admissions and related representations. And the great thing about the Commonwealth Act is that you have notations with examples, and that makes it really clear. So do have a look at the example, which is referred to in Section 81 of the Commonwealth Evidence Act, which will give you a good overview of what this is all about. Now, there is an important decision of Polit against the Crown. This is 1992 176 CLR, and the High Court said some statements in relation to admissions and confessions. And at 196, and I think this is in your text, the High Court said, at common law, before a confession or admission by an accused is admissible in evidence, prosecution needs to establish on the balance of probabilities that it was voluntary. And the case that they referred to there is also another important case of Cleland, C-L-E-L-A-N-D, against the Crown. That's 1982 151 CLR 1. The High Court in Polit went on to say, even if it was voluntary, the trial judge has a discretion to exclude it if it would be unfair to the accused to admit it into evidence. And in addition, the trial judge has a discretion to exclude evidence on the grounds of public policy, evidence that had been improperly or illegally obtained, and again, some really important cases. The Crown against Lee, 1950, 82, CLR 133. A possibly even more important case, Bunning against Cross, 1978, 141, CLR 54. So in the context of confessions and admissions, I'd really like you to consider initially the distinction. Think about some of the statutory provisions. I've mentioned, for example, Section 81 of the Uniform Evidence Act. When I talk about the Uniform Evidence Act, you know that I'm talking, amongst other things, about the Commonwealth Evidence Act. And be aware of the important decisions of Polit, Cleland, Lee, and Bunning and Cross. So we've got all that as a quick overview. Now, from Polit, we have, if you like, the tests, the steps to follow to determine the admissibility of confessional evidence. So we're talking criminal law proceedings where someone is alleged to have made a confession. Now, you'd think automatically, without question, that that's important evidence. Prosecution should lead that evidence. Someone's made a confession, so that's as good as having a conviction in the bag, isn't it? Well, not necessarily, because even though someone may have made a confession, that won't necessarily find its way into admissible evidence. So as defence counsel, you've got to explore these possibilities and determine a few things. Now, firstly, and here are the steps. Number one, did the party make the admission? Probably, but that's the first thing. It's got to be the parties made the admission. Number two, the question is, did the party make the admission voluntarily? In other words, it's got to be a voluntary admission. Yes, I'm guilty. I did it. I'll confess to that. You can, to take an extreme example, if someone says, yes, I'm guilty, I did that, and the only reason I'm telling you that is because someone's got a shotgun at the back of my head and has told me they're going to blow off my head if I don't make this confession. So yes, I made the confession, but it's not voluntary, is it? Now, to determine whether an admission is voluntary or not, you need to consider really two things. The first is, was the admission obtained by oppressive conduct? If it was, then it's inadmissible. So if there was force, it's not admissible confession. On the other hand, the question might be, was the admission obtained by an inducement? Look, confess to this and all these good things will happen to you and your family. So that's an inducement. Now, if the answer is yes to that, it's also inadmissible. So for the second step in the Polit test, was the admission voluntary? Consider it in terms of whether there was oppressive conduct or an inducement. Now, the third is, if the admission was deemed to be made by the person, step one, and it was deemed to be made voluntarily, step two, that's not the end of the story, because from a defence perspective, you might argue that it is appropriate for the judge to exercise the general judge's discretion to exclude it. Now, think Section 130 of the Evidence Act as one option. Also think about the Christie direction. Christie is a famous case, so think about the Christie discretion and think about two other discretions. Number one, is it fair? This is common law, but to some degree enacted in statute. And number two, think about public policy discretion. So, for example, even though the admission was made, even though it was voluntary, do we accept that it should go into evidence? Is it fair that it goes into evidence? I mean, for example, if someone makes an admission which is voluntary to an undercover police officer, do we say as a matter of public policy that police officers should be allowed to go undercover and by a form of trickery, you might argue, elicit this voluntary confession? Now, it happens quite regularly, so probably the answer is yes, it's admissible. But you understand what I'm getting at. What if someone investigating the crime does something illegal in order to obtain this admission, which is voluntary? When you're arguing the public policy discretion, you're really saying, look, it was on the face of it, this was a voluntary and therefore admissible confession. But really, given the way police went about it, are you, the judge, prepared to allow this into evidence? Or Marcus is onto it too. So that brings me to number 4, and that is, if neither of those discretions that I've talked about, the fairness discretion or the public policy discretion, available, then generally it will be admissible, but we still have this overriding discretion, this Christie discretion, Section 130, and we can exclude the evidence where the prejudicial effect is greater than the probative value. And that's the decision of Swaffield. Really important case, Crown against Swaffield, SWAFFIELD, 1998, 192, CLR at 159. And thank you, Marcus. So, and that goes with the Ireland discretion as well. So to be admissible as relevant, the questioning must be appropriate. So in the case, the other important case, the Crown against Ireland, IRELAND, 1970, 126, CLR 321. The High Court considered the admissibility of questions and responses. Now, basically what they said is the failure to respond to police questioning in a formal interview is not evidence of an admission. It doesn't prove anything. So that's Ireland. Now, the common law right to remain silent applies, and therefore, generally speaking, no adverse inference should be drawn simply because a person refuses to respond to a question. In other words, the refusal to respond is not necessarily suggestive of an admission of guilt or confession. So we've covered some important cases in this context. You'll need to be aware of, have some material written to assist you in relation to confessions and admissions, admissibility. You'd certainly want something about Pollard, something about the Pollard test.
Sorry.
Yes, Michael?
I'm trying to find that because I don't see it anywhere. So where Pollard is in with a P for?
Pollard.
Yeah.
So it's Pollard against the Crown. And I mean, I'm calling it the Pollard test. Different commentators might call it different things. So, and I'm really basing it on what the High Court said. But even if you don't call it the Pollard test, you need to go through this logical progression. And I must confess, I'm not sure where else I may have sourced that, Michael. But
it's not in our evidence book. And
it's not in the text? Okay.
And so I'm just, maybe everyone else is confused, but my head's just spinning this lecture.
Okay.
So,
Yeah, sure.
I'm not finding it anywhere. So
No. Well, just don't be too concerned about that just now. And you can quote me if you like in terms of providing any response. But do think about the logical progression about admissibility. And you can create, there's no hard and fast rule in this. So where I'm saying maybe there's 4 steps, you could create 5 or 6. And the test that you'd want to consider really turns around, number 1, whether the admission was voluntary, and talk about oppression and inducement. And then if it was voluntary, the next stage really is to talk about whether there is some discretion which should operate to exclude it, even though it was made voluntarily, which is fairness, public policy, or the overriding discretion. Christy. Okay. So, and in that context, do have a look at Swaffield and do have a look at Ireland, which are important cases. And generally, you'll see quite often a reference to the Christie discretion in terms of the ability to of a judge to exclude evidence based on general fairness. Now, by way of example, there's a case. Yes, evidence law in Queensland, South Australia and Western Australia, says Eve is another good case book, and it is. I use that one regularly in practice. It's excellent. But Field is also excellent. So there are a few different case books on this that provide different angles, and the same sort of concepts might be described in different ways or attributed to different cases. So it's not an exact science. And that way, don't be concerned, be comforted by the fact that you can create your own design and model to some degree as well. Now, let's talk about an example of where oppressive conduct led to evidence that would otherwise be admissible being denied. So, Vandermeer against the Crown, 1988, 62 ALJR. Now, don't worry about reading this case, but just read it as an example. So police charged 3 people with assault and sexual offences. And they said there are 2 victims here. And what happened is the complaints were raised at about 5:30 in the morning, and the 3 accused who'd had little sleep and still likely affected by alcohol arrived at the police station relatively early in the morning. They were interviewed during the course of the day until midnight, so very little sleep. And the accused was invited to answer questions of the victims, and the High Court said that shouldn't have happened. The High Court was critical of the form of the interviews, and the questioning was quite aggressive, and it was similar to cross-examination rather than eliciting information. So that's an example where the court had said, no, that's oppressive conduct. Even though there were these voluntary admissions, or confessions rather, we're not going to allow it into evidence. And you can give it different tags quite usefully or quite appropriately. Right, so one of the cornerstones is the judge's discretion, fairness, public policy, and the judge can exclude on those bases. When it comes to the fairness discretion, I've mentioned the case of the Crown against Lee. The one that goes with that is McDermott against the Crown, which was decided 2 years earlier in 1948. So both McDermott and Lee are High Court decisions, and in simple terms, the rule is that a trial judge has a discretion to reject a confession or incriminating statements made by accused if, though the statement could not be held to be inadmissible in evidence, in all the circumstances it would be unfair to use it in evidence against the accused. Now, you're probably getting the sense of a common theme here, that a lot of these leading cases are in a sense saying the same thing, and they are, because they all come back to this issue of fairness and probity in terms of the way in which investigating officers went about their task. All right, so you've got the key cases there that you need to consider. When it comes to the public policy discretion, I would suggest that you think about Bunning and Cross and Pollard. When it comes to the judge's discretion, this general discretion, think Christie. And I think it's fair to say that the High Court applied the Christie discretion in the case of Swaffield. So in general terms, yes, Michael?
I've just got a question. I note in Lee's case that it says that the burden of proof is on the defence regarding whether or not it's unfair. How would you go applying that test?
Yep. In my view, that can be read only to this extent, that the burden is on defence to at least fairly raise the issue. If defence brings something to the table, so to speak, that fairly puts it as an issue for consideration, then that's the extent to which the burden is upon defence. But it's not for defence to prove beyond reasonable doubt that the confessions were admissible. So once defence have raised the issue and given enough to give it some legs and warrant attention, then the ultimate burden still goes back to the Crown. It's a little bit... What's that? Sorry, Michael?
In the text, it indicates on the balance of probabilities.
Yeah.
That require evidence.
It could do, yes. So in other words, it may force the accused to go into the witness box to give this evidence, and that could be reflected in the line of questioning by defence counsel of prosecution witnesses while prosecution are presenting their case.
Yeah, so if they're going to allege then that the police, for example, had unfairly questioned the accused, they would have to put certain things to them, certain allegations, but then they would have to prove on the balance of probabilities that that occurred via some form of evidence. And that would come from the accused.
Yeah, I'm not sure I entirely agree with the commentary in that regard. From a practice perspective, I think that the more appropriate test is putting it fairly into contest. But you can read into different judgments, different tests, and different ways of applying this. And again, I know you're probably saying, well, gosh, this is very confusing in a sense, but there is no one set formula. There's no one set of rules. What we do in practice is, of course, rely on statutory provisions where they exist as the primary argument. Other than that, it's extracting principles from cases and interpreting what is said by the courts and commented upon by commentators, and basing your arguments around that. Right, so what we've been discussing really tonight are exceptions to the hearsay rule, and there are so many of them. So we know the basic hearsay rule, but we're now getting an idea of the extent to which these exceptions exist. And when you're talking about the admissibility of hearsay evidence, you need to adopt a couple of tests. So the first is, and this is a pretty basic one, and this is where a lot of people get caught out. Number one, is the hearsay evidence tendered as truth of the facts as asserted? So in sub Romanium, when going to the witness box and saying, you know, these people are terrorists and they said they're going to kill me, he's not there saying, he's not attempting to prove by those statements that they were in fact terrorists and that they were in fact intending to kill him. What this evidence was tendered or accepted on the basis that it went to his state of mind. These are the things that I heard. I don't know whether they're true or not, but it certainly had an effect on me. And you can understand that. So the first question is this hearsay evidence intended to prove the facts as asserted? And if the answer is no, then the assertion is outside the ambit of the hearsay prohibition, generally speaking. So when we talk about hearsay evidence and the exception, we're really talking about those situations where you are trying to prove the truth of the facts as asserted. So, for example, was that Walton who was speaking, was that Walton who was on the phone the subject of this hearsay statement? So if the answer is yes, and this is the second part of the test, does the assertion fall within an exception to the prohibition against leading hearsay evidence? And if the answer is yes, the assertion will be admitted, provided it is legally admissible and not excluded as a matter of discretion. I'll just go through that again. And this is really the heart of what we've been discussing tonight. So generally speaking, if you're trying to prove something which is contained within a hearsay statement, in order to make it admissible, and therefore to prove something, it must be something that falls within the exception to the prohibition against the hearsay rule, and it must remain admissible and not excluded as a matter of discretion. Okay, now all of this in the context of what happens in practice. So you're in a trial situation, the evidence is being led, and you've got to make your objection immediately. We didn't really practice that in the first assessment. In later offerings of this unit, if I'm given the opportunity, I might introduce that, but it wasn't part of the assessment regime this year. So remember, of course, that if you object to something, you might be objecting to many things. It might be the way in which your opponent asks the question. It might be the content of the question, or it may be or you may object to the content of the evidence being given by the witness. So all of those things may be part of your objection, and it may be part of your objection to what is otherwise hearsay evidence. So if you object on the basis that something is inadmissible hearsay, what are some of the steps? Well, number one, you say the evidence is not from the witness's 5 senses. Number two, that the hearsay evidence is not tendered as truth of the facts asserted. Or number three, it falls within some of the exceptions. And they're the basic sort of things that you need to get around. So in terms of preparing for the exam, what I'd suggest is that you try and chart this, select some of the key cases, select some quotes, and then try and put it in a form that logically works for you. Now that might be based around what's in the textbook or textbooks, or you may decide to go about it in a slightly different way. And there's nothing at all wrong with that, given the degree of flexibility around this area of practice. So do read in your text about the exceptions to hearsay evidence, and bear in mind, following on from what we talked about last week, the sections 92 and 93 of the Evidence Act Queensland that deal with documentary evidence, they're really exceptions to the hearsay rule also. And of course, when you're doing your preparation, do have a look at the Uniform Act, and I'd start with section 59 of the Commonwealth Act, because that deals with the exclusion of hearsay evidence, and it follows on, if you like, from the flowchart a few pages earlier. And if you look at subsection 3 of section 59 of the Commonwealth Act, you'll see notations in terms of hearsay and other exceptions to the general hearsay rule. So do have a look at those, and have a look at the examples. Now, when I talk about the examples, in particular, if you've got your Commonwealth Act, have a look at the examples at the tail end of section 59. And I think I've mentioned this previously. They're good examples to get your head around this issue of hearsay and exceptions to the hearsay rule. In terms of cases, by way of summary, we've talked about a few tonight. Bull, Polit, Ratan, they're amongst some of the cases that you need to consider in general terms, and some of the discretionary cases that we've also mentioned. Bunning and Cross, Lee, cases of that ilk. So any questions about those issues? And you're being very patient. I'll just kick on. Yes, sorry. Yes, Mary?
Can I ask you a question that you haven't brought up yet, but which is
Yep.
in the side, because it's a case, an actual case which is about to start in less than 2 weeks, and it's a similar facts, which was what was on the study guide for this week. And the prosecution has made a special application or leave of the court. They've dropped the police charges and they've substituted them with 3 identical charges. The DPP has substituted the charges against the person with 3 identical charges, but different dates associated with that. And I've been trying to work out what that all means, and then that popped up this week. So I did all the reading on that plus extra reading, but I still don't quite understand. Does that mean that if the prosecution can prove facts in one of the charges, that they can get all 3 on similar facts? It's circumstantial. The entire case is circumstantial, but it is a criminal case in the district court.
Yes. Now, there's a few issues there, and it's a good question, but there are a few issues. Now, the first is, from a practical perspective, bear in mind that prosecution are entitled to change the charges as they see fit. So, for example, someone might be committed to the district court on a charge of assault occasioning bodily harm. However, by the time it comes to creating the indictment, prosecution may decide that it's more appropriate, to charge the person with grievous bodily harm. And that can change at any stage. Or a person who might have been charged originally with 3 charges is now charged with 10 counts in the district court, and vice versa. 10 might become 3, etc. And from a defence perspective, you're always looking to commit the prosecution to particulars, and those particulars can change. So even during the course of a trial, prosecution can make application to change some of the detail, say, for example, the dates where the alleged charges were said to have been committed, or when they were said to be committed. So there's a lot of flexibility there, and it's a moving feast. I know that's a very broad answer to your question, Mary. In terms of similar fact evidence, yes, similar fact evidence can be used to secure a conviction or part of a conviction, but there are very clear guidelines and rules about that. And from a practical perspective, what defence would normally seek to do, for example, if you've got one person charged with having alleged to do acts against 2 people, you'd apply to sever those so that one trial doesn't adversely affect the other one. I hope that makes some sense.
It does, but in this case, it's one charge of one person against another, an adult against a minor. There were completely different direct police charges which have been dropped, and then 3 DPP charges have replaced those. The wording is exactly the same. The police charges were originally about a particular date. The DPP charges are just saying basically the same thing, which are telling us nothing, that a noxious thing was administered, causing harm, and 3 different dates. What I guess my question is, that I'm very confused about in trying to work out the practicality of this case, because I am assisting with the defence, and there is a solicitor and barrister, only because of the family. But what I don't understand is, in applying for leave to the court on similar fact evidence, which is what they've applied under, hasn't been granted yet, by the way, by the judge, but does that mean, because this was a discussion that I was listening to between the solicitor and the barrister, I'm thinking I can't find anything to back this up, that if one of those charges are proven, the other 2 can then be proven without presentation of any evidence at all? Is that
No, you still need. We're probably getting into too much detail, Mary. But no, you still need. The Crown still needs to bring proof.
It has to meet the burden of proof.
It does on each one of the charges.
Yep. Thanks. That's what I've been able to work out. So that was my question, I guess. Thanks.
Yeah. No, that's good. All right. So where we'll pick up next week is in relation to issues around character and propensity, talking about someone's reputation, their behaviours in the past, and how that may affect issues in terms of the probative evidence before the court. All right. Well, thank you all for your patience. I know tonight's been a tough session.
Got a question.
Yes, Michael.
Sorry. Yep. So I thought we were doing that this week. So I think this is where
we're behind.
Totally lost, because I prepared for that today, and then we're doing something completely different. It took me 15 minutes to catch up. No,
because I spent so long in terms of going through material relating to assessment 1, I'm behind. So okay. I'm about well, actually, yeah, I've just started on just touching now on that last statement on the material for this week. So I'm just less than a week behind. But you're right. So the work that you did leading up to tonight will serve you well next week.
All right, I just need to go back and read last time, because I felt like I was watching Dutch tonight. So.
Okay, thank you, Michael. But well picked up. All right, all good?
John,
Okay.
just one
Yes,
quick
Michael.
question. There you go. With Polit's case, is there any reason why, because now it forms part of a new exception to the hearsay rule about telephone evidence, why wasn't it declared by the court there that it was a form of res geste?
Well, I think it was, but I think the court, from memory, adopted an approach of saying it may be res geste, but it may also, because these things happen, it might be one or it might be the other. And I'm just trying to think of the case that we dealt with actually tonight, where the House of Lords actually made that type of statement. So, yeah, and you can argue these things from different perspectives with equal force. And again, there's not necessarily a right or wrong answer, but that's a really good reflection, Michael. I know that's a vague response, but I hope that's sufficient. So, all right. Any questions? All good? All right. Thank you all very much. We'll see you next week, same time, and keep your reading going, weeks 10, 11, 12 in particular. We'll see you next time. Bye then.